He's been taken to the back. There's banging on the back. He's the only person back there. And so I want you to know nobody has harmed him or hurt him. Your counsel for your son asked for a short break so they can explain to him as far as what's coming in and why it's coming in. But it appears that he doesn't want to hear that. So this trial is going to continue. Punishment may continue without him. I would hate for him to be brought out strapped down, which is what will end up happening. Because the deputies don't want to bring him out. So things may happen. So that's where we are. And well, well, the only thing is I don't know if the deputies would allow you in the back or not.
Right from the start, the tension is thick. The judge is trying to calm a worried mother, but in the background, there's chaos. Her son, the defendant, is banging his holding cell. This isn't just courtroom drama, it's a real battle to maintain order while protecting the trial's integrity.
All right, Deputy Mahia, Deputy Laura. All right, so, but he's not going to be released from the cell. Okay, so he's inside the cell, so that this trial can continue. I'll allow you to go back every chance, leave your purse and everything out here. You can leave it there. No one will bother it. State, do you have any objections to her speaking to him?
Absolutely not. You're on.
Yes.
One of our main people, she's present.
Yes.
Again, trials,
Well, let's take care of this first, and then I'll take care of it. Okay. So if you'll, I'll go back there with his mom and the other attorney, please.
Here's what the judge means by strapped down. In extreme cases, a disrupted defendant can be physically restrained in the courtrooms, sometimes even with restraints visible to the jury. But that can prejudice the case, so judges tread carefully. This warning is a last resort, and she's hoping mom can help avoid it.
Yes.
You can get behind prejudicial. You don't want to see the next one.
I mean, he just needs to hide the handcuffs, and we'll see how he does. And if he proves that he can remain calm, then the jury won't see him. And what I can do is, when the jury comes in, everyone just remains seated. And what I'll tell the jury is everyone is remaining seated because I request that they remain seated. And I'll say something because of the microphones, so that way they won't know.
You're on.
Yes.
We request for the record. Mr. Morganfield, yeah.
Oh, we can go on the record. All right. You're requesting that he be uncuffed, is that correct?
Yes, Your Honor. Due to prejudicial nature, he is a short report and will be.
All right. So, all right. Thank you. So that will be denied. And so that the record is clear. Mr. Morganfield became disruptive in the courtroom. The court took a recess. Approximately, I believe it was 2:13, and I told the jury that we would be back at 2:20, and I allowed Mr. Morganfield's mother to speak with him. The deputies took Mr. Morganfield back in the holding cells.
Now here's a classic. Defense move asking to remove visible restraints in front of the jury. Why? Because shackles scream dangerous criminal and could sway the jury's emotions. But the judge has already witnessed the defendant's outbursts. Do you think she's going to risk it?
Mr. Morganfield was banging on the holding cells, being disrupted from the back. Both defense counsel thought that his mother would be able to calm him down. His mother was allowed to go into the back. I could still hear yelling from Mr. Morganfield in the back. And we are here at 2:30, 2:40. And the reason why we are here at 2:46 is because it took 20 minutes for Mr. Morganfield to come down. So the court will have Mr. Morganfield remain with handcuffs on. If Mr. Morganfield is able to not be disrupted with the handcuffs on, then the court will consider, of course, with input from the deputies who are in charge with security, whether or not they should be removed. Off the record, the court has been informed, both the state and the defense and Mr. Morganfield, that they are to remain seated when the jury comes in, so that the jury will think there is no disrespect to the court or them. The court will instruct the jurors that I have asked both the defense and the state and Mr. Morganfield to remain seated for technical, logical reasons. And for the record, from here, you cannot see that Mr. Morganfield is handcuffed because his shirt is covering the cuffs.
Yeah, he also has leg restraints on. Also, we can't hear.
All right.
It's not covering. I'm seeing, you know what I'm doing.
All right, Deputy Mejia and Deputy Laura, with regards to the handcuffs to the legs for courtroom safety, do you believe that those should remain?
Yes, sir.
All right, those will remain. Mr. Morganfield, you will just need to put your legs in between the two legs of the desk. Yes. Yes. And so for the record, the wooden cabinet is being moved in front of Mr. Morganfield's leg, and the jury will not be able to see his legs. It rolls, Mr. Cantrell. No. No. All right, we're going to bring the jurors in. All right, the verdict form appears to be in proper order. If then it could be rise, please. Okay, count one verdict form reads, we, the jury, find the defendant, Alexis Morganfield, guilty of the offense of sexual assault of a child as charged in count one of the indictment. Count two reads, we, the jury, find the defendant, Alexis Morganfield, not guilty of count two. Count three reads, we, the jury, find the defendant, Alexis Morganfield, not guilty of count three.
A little longer than a few minutes later.
Here it is, the moment everything has been leading to. Guilty on count one, sexual assault of a child. Not guilty on the other two counts. This split verdict tells us the jury was selective, weighing evidence on each charge separately. But even one guilty count here carries years in prison.
Alright, I'm going to pose the jury verdict, which is first excuse time served for the charges to registration. Did you have a chance to review the final trial court certification charges? Did you understand it? Well, you do have a right. Well, you do have a right to stop right to be out defense. Are you planning on how will appeal or not?
I will not be. Now,
6 years behind bars, plus mandatory registration as a sex offender under Chapter 62. That registration can follow someone for life, affecting where they live, work, and even who they can be around. And if you're wondering, no, there's no house arrest option for this type of conviction.
Next steps with that in the next. And we'll be following this is fine. Yeah.
Oh my God. After I got another case, Miss Morganfield, I'm a business.
Yeah, reason. And she did take it off tomorrow. Tomorrow's nothing.
So, drop by tomorrow and we'll make sure